Good morning to you, and good afternoon to you. I'm Ari Melber in today for Dylan Radigan, and the big story today is the Supreme Showdown. All eyes are on the U.S. Supreme Court today as it completes the first of 3 straight days of oral arguments over President Obama's health care law. It's also the first time since Bush v. Gore in 2000 that the court is releasing audio tapes of the arguments the same day as the arguments took place. Now, one of the pivotal questions this court will be considering and will have to answer to decide the case is whether the insurance fines that are linked to the individual mandate are just a tax. The court already hit on that issue briefly today. Let's take a listen.
This is not a revenue-raising measure because if it's successful, nobody will pay the penalty, and there will be no revenue to raise.
Now, what we have here is something that's in a different statute that doesn't use the word tax once, except for a collection device.
Now, that might sound like some legal jargon, but the point is whether Congress has the power to make you buy insurance. A decision is not going to come until later this summer. Now, we begin our coverage of this big day with NBC Justice correspondent Pete Williams on what happened and what we can expect when things really heat up in the arguments tomorrow.
Ari, a blustery day here at the Supreme Court. Lots of people outside. Inside, relatively sedate argument today on the first question the justices have to confront this week. Now, it has to do with a 150-year-old law that says you cannot challenge a federal tax before it goes into effect. Now, here's why that's a question. The health care law says if you don't buy health insurance, you have to pay a penalty at tax time on your tax form to the IRS based on your income. Now, some lower courts have said, therefore, this is a tax, and the courts can't hear this until it takes effect, until the insurance mandate kicks in 2014. So that was the question today, but it seemed quite clear that none of the justices believe it's a tax. None of them believe this is a showstopper. So it seems quite clear the court believes it can go on to the main event, which comes tomorrow. That's the constitutionality of the health care requirement, the so-called individual mandate. The question is whether the Constitution gave Congress the power to do that. And 2 other questions the court will hear on Wednesday. If the Supreme Court were to decide that the individual mandate is unconstitutional, can you carve that out? And would the rest of the health care law survive? And then Wednesday afternoon, a challenge brought by the states who are challenging the expanded Medicaid requirements that they'll have to follow under the health care law, both in terms of the number of people covered and the additional kind of coverage that they have to provide. So it seems clear that we're on to the main event, and that will come tomorrow. Ari?
Thank you. Now, tickets for this court session were some of the hottest items in D.C. There were about 400 total. The first 60 went to the public in a flash this morning, and some were waiting all weekend to get inside. One person who did not have to wait and was in court for today's oral arguments is a man who sued to overturn the health care law the very day it was enacted, Texas Attorney General Greg Abbott. Thank you for being with us.
My pleasure, Ari. Great to be with you.
Absolutely. Now, Mr. Abbott, we do know what you want to happen here. In your view, though, what do you think is the strongest grounds for the Supreme Court to overturn this law?
Well, it's clearly the individual mandate that compels all Americans to go out and purchase a product. Let me give you a couple of reasons real quick why we think that's so compelling. First, the Supreme Court will not have to overturn any precedent to agree with us that Obamacare should be stricken down because this is the first time in American history where this kind of mandate has been imposed. Second, if the mandate were to be upheld, if the Supreme Court were to allow Obamacare to live on, it would have challenges with regard to where the limits are about where the line is drawn on congressional power to mandate that other things be purchased. The third thing, Ari, and that is that this law is unnecessary. There were constitutional ways that Congress could have passed this law to expand health care for everyone through the tax and spend clause. Congress did not choose that constitutional pathway. Instead, Congress chose an unconstitutional pathway through the way of the individual mandate.
So, Mr. Abbott, let me pick up on the first point you made, which is that this is the first time this has happened. Obviously, precedent is an important issue anytime you go before the court. Don't you think, though, that the argument that the courts have seen before, that Congress has the power to make regulations that involve activities, you know, the inactivity-activity distinction has been bandied around a lot. But if you have Social Security, which has been upheld as constitutional, you know, that requires you to pay into something, whether you use it or not, whether you choose to use it, whether you live long enough to use it. So how do you really distinguish this in the arguments that you and your team are ultimately making?
Right. There are constitutional ways that Congress can clearly completely redraft and reconstitute the health care system in this country and achieve exactly what they sought to achieve at Obamacare, through the tax and spend clause. They didn't choose that pathway. On the activity, non-activity, this is the first time in the history of the United States of America that Congress has attempted to regulate inactivity, to try to force someone into the stream of commerce and then regulate them. And that's why we feel, the states feel, that we are on solid ground, that the Supreme Court can clearly uphold this without overturning a single precedent.
So let's do another law school hypothetical, since this is the big day for those. You talk about the first time they're forcing you out of inactivity, but all sorts of laws exist that say you have to wear clothes in public, right? And that means as a practical matter, you have to buy clothes, right? Isn't that taking inactivity and slapping a cost on it?
Well, you're actually making my argument, and that is there are certain things in life that everyone accesses actually even more than health care. Food, water, clothing, and shelter, and yet Congress has not required all Americans to go out and purchase those items, and Congress does not have that authority. In fact, or if you were to go back to when Barack Obama was a candidate for the United States president, he said that the individual mandate simply is not that simple, because if it was, he said he could simply mandate that everyone go out and purchase housing, and that would solve homelessness. He obviously has had to change his tune after he got elected and after this law got passed, but his earlier rhetoric shows the impracticability and unconstitutionality of this sweeping mandate.
Well, I take your point. I'm not sure that whether his position has changed has a constitutional dimension. Politicians could change their mind, and their former position may or may not be constitutional. But I want to get to one other idea here, which is this tax definition. Obviously, today, that was a big question over whether the court should hear this case now. But putting that aside and going to the heart of the matter, would you and your team here that is saying this has to be overturned take a different position if Congress went back to the drawing board, rewrote this bill for the same goal of getting people covered, but simply explicitly called it a tax from the beginning with regard to the penalties for not being in the system?
Right. Our argument all along has really not been raising any issue about whether or not health care is good or bad, or whether or not the expansion of health care and covering all the things that Congress wanted to cover here. We don't address that top side or bottom. The only issue we are really attacking is whether or not this individual mandate is unconstitutional. If Congress goes back and this law is overturned and Congress chooses a different pathway and finds a constitutional way to impose this law, we would have to go back and rethink our legal situation. But standing alone, that hypothetical doesn't raise an issue of constitutional magnitude.
Well, Mr. Abbott, let me push you a little bit. The question is simply whether calling it a tax as a means to encourage people to get involved. We have a tax structure that can reward you for having a mortgage and deducting that. We have a tax structure that in the corporate context can reward you for selling hybrid cars. So I guess what I'm trying to get a sense of, because you've taken on this issue from day one, you're one of the spokespeople for what I would call a conservative legal view here, would it make a difference if you just called it the taxing power and moved forward that way?
Ari, the answer constitutionally is yes, and that is what is so confounding constitutionally about this case. Congress could have used its tax and spend authority under the Constitution to achieve what it did achieve in this regard through unconstitutional means by imposing the individual mandate.
Okay. Well, thank you for that. Let me turn to one other perspective here, which is all of these crowds, including some presidential candidates around the court. When is the last time you've seen this level of public interest? And as a litigator, what do you make of that? Does that have any impact inside the courtroom? Technically, we're told it shouldn't matter.
I think it does have a huge impact. And to help you understand this, I was here personally to argue in defense of a Ten Commandments monument on the Texas Capitol grounds. I've been here for Second Amendment cases. I've been here for a lot of different kinds of cases. I've never seen this level of heightened activity outside the courtroom. And let me explain why this is significant. Because the United States Supreme Court would, even if it believed a law was unconstitutional, I think it would have hesitancy to strike down a law that was popularly embraced by all of Americans. As you know, this law, a majority of Americans disagree with the law. In fact, a majority of Americans believe the law is unconstitutional. So that puts the people on the side of a court decision that would side in striking down the law.
Does that make you a legal realist? Do you think if things are more popular, that affects how the justices do their reasoning?
It doesn't do it that way, but it certainly could play into the consciousness of them. If this were something popularly embraced, like let's say the Social Security system or the Medicaid system in general, I think that it would cause the court to have some pause in order to strike down a program that millions of Americans are already counting on. Because of the way Obamacare was implemented, where it's not yet in effect, it really doesn't go into effect, the large part of it, until 2014, and because of a majority of the country are clearly against it, it's not as if the Supreme Court will be striking down some important law that a lot of people have already embraced.
And also, what about judicial activism here? You are well versed in these arguments, and they can go both ways. But there are a lot of folks who say that, and we're going to be talking about this on the show, that basically if the court comes in and really does the most ambitious thing and strikes down this signature achievement of this president, it will feel to many like they are getting in the political arena and they are being activist judges. What is your response to that, which really is more about the politics than what happens in the courtroom tomorrow?
Well, the activism label actually has more to do with the way that people talk about what the court does. The reality is whether they are activist or non-activist depends upon how closely they adhere to the Constitution. And what the Constitution does here is to limit Congress's power. We believe the court actually would be activist if it upheld Obamacare by empowering Congress to do things which it is clearly not authorized to do under the Constitution.
All right. Well, Mr. Abbott, we know you've been in the arena on this on day one, so we appreciate you coming to us during this very busy week for you and sharing your views and your perspective.
My pleasure, Ari. Thank you.
Thanks.